the administration of upstream business under the Petroleum Industry Act, the PIA, which is our technical session for today, which is going to be by Dr. Austin Uku Kanu. My name is Irene Photo. I am the YP co-chair for SPE Lagos Section 61. I work with Bond Global Energy Projects Limited. So just to run through the program of events, we'll be having the welcome, which has been done, and then the safety brief, opening remarks by the section chairperson, introduction of the presenter, the presentation, the summary of the presentation, questions and answers segment, and the announcement and vote of things. Thank you. So just for the safety moment. So during this time, let's just remain vigilant, and also let's be our brother's keepers. Kindly drop in your messages, comments, questions in the chat, and they will be attended to during the question and answer segment. So we'll be having the opening remarks now by Mrs. Priscilla Nwere, who's the section chairperson of SPE Lagos Section 61.
Thank you, Irene. Good morning, everyone. Thank you for joining us today for this webinar. I believe that conversations about the PIA are something that everyone is happy to have. And I'm glad that we at SPE Lagos could bring this subject back today. At this session, we'll be discussing the administration of upstream business under the PIA, as Irene had introduced in the beginning. The topic of today will deal with the laws, regulations that govern the administration of upstream operations in Nigeria. We bring to you today our resource person who's an Esquire and a subject matter expert in this regard. So I'd say thank you, Dr. Uku, for coming to talk to us today. I have no doubt that the next 1 hour will be well spent. So everyone who's taking time out to join us today, I say thank you. And I encourage you to please continue to follow SPE Lagos on all social media platforms. That way you engage with us and you get first-hand information about all the programs that we'll bring to you. Thank you for joining. Enjoy the session. Irene, back to you. Thank you.
Thank you very much for that introduction. So I would like to now introduce our speaker for today. Austin Uku is a consultant petroleum engineer and a teacher with more than 15 years experience in petroleum asset management and production optimization. He holds a PhD in petroleum reservoir engineering with domain knowledge in reservoir fluid property modeling, field development planning, decision-based integrated reservoir modeling, resource volume estimation, and reporting to the SEC and SPE standards, petroleum economics and fiscal regimes, OPEC gas condensates auditing procedure, and computational mathematics, and was called to the Nigerian bar and enrolled into the Supreme Court to practice as a barrister and solicitor. His practice areas are the oil and gas law, corporate practice, tax consultancy, intellectual property law, and regulatory compliance. He's the lead solicitor of Austin Uku and Co., a law firm with special interest in rendering legal services with optimum client satisfaction as its basic focus. Austin Uku is a registered engineer with Coren, and he's a member of the SPE, Nigerian Society of Engineers, Nigerian Bar Association, and National Registry of Environmental Professionals. Austin Uku possesses great inquisitiveness to identify new opportunities that promote common good. He has the potential drive to stimulate and create positive energy in others and the ability to work with individuals as a team. He has been a speaker in many forums on the collaboration between the industry and academia, as well as the legal framework of the Nigerian oil and gas industry. So welcome to our speaker. Dr. Austin Uku. So we welcome our speaker now to on the administration of upstream business under the Petroleum Industry Act.
So, are you online? I see you online, but you're muted. So can you unmute yourself?
Okay, good morning. Sorry, the host did not allow me to unmute before now.
Good morning.
Good morning.
So you're welcome to the section for today as we hand the floor to you now.
Confirm you can see my screen. Please, can you see my screen?
Yes, we can.
Okay. All right, today's business is addition of upstream business under the Petroleum Industry Act. So the content will go okay, we'll cover the basics of asset acquisition. We'll also deal with upstream license matters such as grant of license, renewal, relinquishment, revocation, and assignment. Assignment is another way to acquire assets. We'll also cover marginal field under the PIA. We'll discuss conversion of license, utilization of acreage. We'll also cover natural gas flare, environmental management, decommission and abandonment. And if time allows, I will just discuss the cost of jurisdiction to entertain upstream matters. So the objective of this presentation is to deliver a framework to enable the E&P companies to continue to produce, improve, and innovate. 2, to avoid the waste associated with litigation, stroke arbitration by acting in the first instance within the bounds of law. You will see examples of cases where companies and the government are tied down in courtroom for years, wasting resources and productive time for not acting within the bounds of law. Improve confidence in shareholders and stakeholders in the management and administration of E&P business in Nigeria. This is mainly due to because the PIA has provided clarity of law. Four, we provide understanding what the PIA means today to us and what is meant to tomorrow. The framework of the PIA is divided into 5 main parts. The first part is governance, which details how the government structures itself to organize the industry. That alone is a business matter, government matter. 2 is administration of the oil and gas industry, and it's divided into 2 parts. There is the upstream administration, which is our concern today. There is a midstream and downstream administration, which is a later talk altogether, a different model. However, the midstream and downstream deals mainly on gas development and commercialization. The third module is the host community development, which deals with interaction between the company and the host communities. The fourth leg to it is the fiscal framework, which deals with the business, the economics of E&P business, oil and gas business. And this economics of oil and gas business cannot, like administration, be decoupled. The administration can be decoupled into upstream, midstream, and downstream, but the physical system cannot be decoupled because the revenue accruing to the company also traces into the midstream or the downstream. So for you to do effective economic analysis, you must couple the downstream, upstream, and midstream together to be able to do effective economic analysis. So there's a legal part which deals with jurisdictions, which court can entertain matter, what matter can be brought, and other ancillary matters altogether. So because this presentation is mainly on license, upstream is guided by license, 3 main licenses, which are the petroleum exploratory license, petroleum prospecting license, and petroleum mining license. The exploration license is for exploration. The prospecting license is to drill exploration and appraisal wells and to do production tests. It can also win and carry disposed crude oil, condensate, and natural gas on the basis of the production tests you've done. While the mining license is purely for winning, work, carry away, and dispose crude oil, condensate, and natural gas, as in section 71. As I read through, you see, I will quote all the sections. Most of the talk I'm going to say is directly from laws and not from me. So oftentimes you see where I take the laws from, not exactly what I tend to see. It's what the law has said. So what right do the company have on the license? For the other ones, it is exclusive. Who is the guarantor? Who grants the license? The license is granted by the commission for exploration license by the commission, or for a license is granted by the minister upon recommendation by the commission. The duration is basically 3 years for exploratory license and additional 3 years again. For the prospecting license, onshore and shallow water has at least 6 years, while the deep water has at least 10 years, comprising of initial 5 years of exploration and 5 years of extension. While the mining license has 20 years renewable over and renewable. So what is acquisition is by bidding processes. The bidding processes must be fair, transparent, and competitive. It must be in compliance with the PIA. It must be conducted in the presence of representatives of the Nigeria Extractive Industry Transparent Initiative, the federal government, the Federal Ministry of Finance, and the Federal Ministry of Petroleum Resources. What are the legal issues here? It's whether the compliance with these processes will invalidate the license. In my opinion, no. Determination of winning bids. So once the bid is started, the winning determined on the basis of what? Specified bid parameters. So the commission has bid parameters, and such that the combination of the bid parameters based on point system assigned by the bidder in a manner that the bidder will be with the highest aggregate number of points shall be the winning bidder. So what are the bid parameters? Signal must be paid, royalty interest will be paid, the profit split, work program commitments, and other parameters may be defined specific to the bid round. So, but the thing is that before you give a license to a bidder, that license will be accompanied by a contract to avoid problem. So if you have to give a license, you give the person either a JV, a PSC, SORIX, or service contract. Now, what are the bidding processes? Formal announcement, launch of bid portal, expression of interest, pre-qualification announcements of pre-qualified bidders, payment administrative fees, conduct of bid, publication of winners of the bid round, and then bid shall be executed. The bidder shall not execute a confidential agreement before assessing data. Requirement to grant license. So within 90 days of winning the bid, the winning bidder must provide the parent company guarantee. It must provide the work commitment guarantee, the applicable fees, pay for the rent for the first 1 year, pay signature bonus, duly executed model contracts, and such other matters as may be prescribed under the guideline. In federal government of Nigeria and others, the Zebra Oil Limited, the application letter by Zebra on the 24th November 1998 for the installation of PIA 248 was approved on 8th of March 1999. The award letter stated that the offer was subject to the condition it allowed that Zebra pay application and bidding fees of 50,000 naira and $10,000 respectively, pay signature bonus and reserve value of $20 million, pay the said statutory fee and confirm acceptance of the offer within 30 days of the letter. And if the amount due was not paid by that date, the acreage may be reallocated without further reference to Zebra. In an acceptance letter on 22nd March 1999, Zebra paid the sum of 50,000 naira and $10,000, being the payment for the application and bidding fee, respectively. In the same letter, Zebra promised to pay the signature bonus and the reserve value of $20 million in due course, and sought clarification on how much of the $20 million represent the signature bonus and how much represent the reserve value. In the letter dated 13th of April 1999, Zebra sought further clarification on the breakdown of the $20 million. On the 15th of April 1999, DPR wrote a letter stating that the payment of the $20 million could be in 2 installments within a stated period of 3 months. On the 28th of May 1999, Zebra wrote DPR reporting that returned the payment of $1 million out of the $20 million and requesting for a 3-month extension effective 7th of June 1999 to pay the second installment, but was granted 45 days effective 1st of June 1999. On the 8th of July 1999, DPR wrote Zebra to cancel the license. The issue whether the award letter and acceptance of same creates a legal binding contract between the government and the licensee. The Supreme Court held that offer to enter into a unilateral contract is accepted on commencement of performance, even though completion of performance is a condition precedent to the offeror's liability to perform his promise. The Supreme Court therefore confirmed the judgment of the Court of Appeal, affirming the decision of the Federal High Court that there was a valid contract between the parties. It then directed the parties to complete the obligation under the contract. My take. Section 74.2 settles the issue when it mandates the signature bonus to be paid in full prior to granting of license. Because if Zebra has paid the signature bonus in full, this issue would not reason. So it was about the government did not say Zebra how much of that 20 million is signature bonus and is reserve value. So Zebra Oil could not know exactly how much is the signature bonus which is required by law to pay in full. So section 74.2 has settled that problem and we can go on with it. So grant of license. License will be granted to qualified candidate by commission upon the recommendation by the commission. But for petroleum exploration license should be granted by the commission, not by the minister. Licenses are granted only to companies cooperating in Nigerians, and license should be granted in companion with the contract. There's always a legal issue here. Whether the minister is bound by the recommendation of the commission, that's the only issue that can be decided here. So the minister is not bound by the recommendation of the commission because the minister has the responsibility to oversee the petroleum industry on behalf of the president. Section 3(1)(b). Again, the president can also be the Minister of Petroleum Resources. The commission of the commission is merely advisory. Howbeit, the minister shall inform the commission of the decision to grant or not to grant within 90 days of the application for the lease. Otherwise, the license is deemed granted. So if the minister refuses to act within 90 days, that application is granted. So now let's look at how to administer petroleum prospecting license. So we said before it must be granted by the minister upon recommendation by the commission. So what a condition precedent for extension of time to grant that in where there's a discovery of that's discovery that merits appraisal. So if your discovery merits appraisal, you can extend time. Where there's a significant discovery have been made, declared, you can extend time. Where FDP have been submitted, you can extend time. So the right to the holder is that he has exclusive right to drill exploratory well and appraisal wells. He also has this right to carry away and dispose crude oil or natural gas to sell his property. But this is not in the previous act because the previous act cannot sell under processing license. Minimum obligation under the license is that you must do your work program, declare significant recovery if you have one, or declare commercial discovery. So what are the work program? Because that's the first thing you should do if you have a petroleum processing license. It's a program that a commitment that you fulfill all the terms, the work stated in the contract. So the commitment, you also have a commitment to drill a new exploratory wells. You must make that commitment in your program. So the areas in the program should be 350 square kilometer for onshore, 1,000 square kilometer for deep offshore, and 1,500 for frontier acreage. This is different from the old region PIA, and that is 1,000 square miles, equivalent to 2,590 square kilometers. So the next stage is that if you have a immediate discovery, if you immediate appraiser, what's the process? The licensee shall inform the commission within 180 days. Within 180 days of that the discovery merits appraisal or that he does not have interest. So he has option to inform the commission that yes, this thing merits appraisal or I do not have interest in this business any longer. So when it merits appraisal, what conditions we met? That the commitment to appraisal program. So what approval of appraisal program will be done by the commission within 60 days. So you must complete discovery, the completion of appraisal program must be, you declare commercial discovery, declare significant oil and gas or significant crude oil discovery, and inform the commission that the discovery is of no interest if you so wish to. So significant and commercial discovery. So there's significant discovery. If you made a significant discovery or you made a commercial discovery, there are two different things. So that is why resource book is important because once you evaluate your resources, your petroleum resources, you know exactly which stage you are in. Are you making a significant discovery, or are you making a commercial discovery, or are you still at a point of appraisal point? So you have to know at which point you are. So let's say this person is at a significant discovery. In that case, the law allows him to inform the commission as well, and he has to retain the area because once he makes a significant discovery, he retain the area. But for commercial discovery, the impact is that you have to follow up with what? FDP. Now, the field development plan, the criteria is plenty, and that is where I want people to understand that oftentimes when we file our FDP, we file in mostly the technical aspect. We neglect some of the other aesthetic aspect of it, which if a new government comes in, they decide to evaluate your FDP, and then you fall into a trap. Because never a time that government cannot check their programs. They can start to say, okay, let's check FDP for the last 20 years. And they find that maybe this person has not included some problems here. If you look at this place, you have to include local content, environmental management, decommissioning plan. You have to include elimination of gas flare. You have to include recruitment of local personnel. These things are things that have to be part of the FDP, including the technical and commercial aspects. So don't overlook this aspect because they're important. So relinquishment of petroleum prospecting license. There are conditions which you relinquish if the relinquished area is not appraisal area, it is not retention area, not based on national grid. Two, where the retention area has been declared, relinquished upon the expiration of the retention period. Because if you declare, if you say you made appraisal, significant recovery, you retain the area. But if you cannot retain the area after the retention period, you have to relinquish. Three, where the licensee does not submit FDP or work commitment within 2 years of the creation of commercial discovery. So if you made a commercial discovery, you fail to submit FDP within 2 years, then means you have to relinquish. So effect of relinquishment is that license will expire, relinquished area vested to the government will revert to government, and any paid rent is not refundable. So if you want to convert a petroleum prospecting license to mining license, the first thing you have to do is to commit to work program. In the process, you ask yourself whether the license expired. If you expired, the expiration effect will take effect upon relinquishment. You don't just relinquish that because the license expired, you relinquish. No, it is not the law. Even if you expired, there's a condition precedent that you must relinquish first. But let's say it has not expired, you declare discovery. So once you declare discovery, if no discovery was made, that means you have to relinquish compulsorily. But if you have made discovery, you inform the commission of two things. You have no interest, you relinquish. You made appraisal, you go on to commit to appraisal program. And in the process of committing appraisal program, the question is, have you license expired? If it has expired, you relinquish. The expiration will take effect upon relinquishment. You don't just relinquish. However, if it has not expired, you cannot make a declaration. I don't have interest. That means if you don't have interest, you relinquish. You can say, okay, I made a commercial discovery. In that case, the onus lies on you to submit FDP. And if you submit FDP, if it's approved, if it is not approved, you relinquish. If it's approved, petroleum mining license will be granted to you. Or you could say that the discovery is significant discovery. In that case, you retain the area. You've made a significant discovery within the restriction period. You ask yourself, has the restriction expired? If it has expired, you relinquish automatically. There's no grammar here. But if it has not expired, you now go back to do commercial discovery. So commercial discovery. If you have not declared commercial discovery, you relinquish automatically. But if I declare the commercial discovery, any license will be granted to you. This is just the procedure of converting your petroleum mining license to petroleum processing license to petroleum mining license. Now, in South Atlantic Petroleum Nigeria, Limited and Petroleum Minister and others, on 23rd of February 1998, South Atlantic was awarded OPL 246 for 5 years tenure, extended for another 5 years, and was therefore due for expiration on 28th of March 2008. Upon commercial discovery, South Atlantic applied to DPR on the 8th of March 2004 for the conversion of the existing part of the said OPL 246 to OML. On the 21st of February 2005, DPR converted to South Atlantic government's approval for the conversion of OPL 246 to OML 130. On 27th of June 2005, South Atlantic applied for an additional OML deriving from the OPL 246. However, its application was rejected by letter dated 1st of March 2006 and 21st of March 2006. The issue here is whether the PL is automatically relinquished upon expiration of a fraction of time. That's what we are discussing here. Can I relinquish my PPL upon expiration? The trial court held that there was nothing unlawful in the decision of the federal government, as the residual of OPL 246 was automatically relinquished and reverted to federal government upon the grant of OML 130 to the applicant. The leave sought by South Atlantic was consequently refused. Despite with the decision, South Atlantic appealed, and on 29th of April 2008, the Court of Appeal ruled that the grant of OPL 246 expired on 28th of March 2008. With expiration of the period, there seems to be no life left in the issue in the appeal. The appeal court did not give South Atlantic an opportunity to be heard. South Atlantic further appealed, and the Supreme Court held that in the circumstances of the case, this appeal succeeded on the ground that the Court of Appeal was sent back to Court of Appeal to decide the issue between the parties and any other issues that could be decided upon this. So the issue the Supreme Court had was that the South Atlantic was not heard, not on the merits. The position of the law on relinquishment under the Petroleum Act is vague. Under the PIA, the position of South Atlantic that it has not relinquished any portion of OPL 246 has the force of law. So the South Atlantic was correct to argue that they did not relinquish their portion, because that is expired doesn't mean you have relinquished. There are condition precedents to relinquishment. The law is that where a declaration of commercial discovery has been made, the PPL shall be extended until related PML have been granted or denied. Grant of PML to PPL. Here, you can only grant PML to a holder of PPL. That's what the law says, on certain conditions. The condition that you might develop a commercial discovery, or that you will start to continue production in the area which shall be developed. In NNPC and others versus Fanfa Oil Limited, FAFA was granted OPIA 216 on the 5th of May 1993 and later entered into a technical partnership with Star Deep Petroleum and Petrobras. On the 23rd March 2000, MPC wrote FAFA, wherein it purported to acquire 40% of OPIA 216. FAFA sued at Federal High Court Abuja and the court found in its favor. Subsequently, FAFA applied for OML and it was granted on 13th of December 2004, converting OPIA 216 to OML 127. And MPC wrote FAFA on the 27th of January 2005, claiming that the equity has been taken over by government, bringing the parties participating interest in the derived OML 127 to be as follows: NNPC 50%, Star 32%, FAFA 10%, Petrobras 8%. The legal issue here is whether the PML can be granted to another person or person except the holder of PML. And the court made an order directing that all the interests of FAFA should be returned to him, to FAFA Oil, and that their position was illegal. Analysis. The decision is in line with the law that PML should be granted to PPL holders who has met the conditions. That's the grant. He must have met the conditions. FAFA is the holder of PPL and is liable to be awarded the PML derived therefrom, notwithstanding that it is a technical partnership with Star and Petrobras. Again, this action of government would have been valid before the law if it was taken before PPL was issued. So if government has taken this action before the issue PPL, the action would have been right. But because they've issued PPL, the vets have been taking the action they've taken now. Renewal of PML. So it will be renewed every 20 years. So you have to apply for it. It's compulsory. And before you apply 12 months before the expiration of the PML before it can be renewed. Condition for renewal is that you have to pay all payments must be made in full. He has to fulfill all and not default in any obligation related to the license. It has to discharge all operational obligations in compliance with applicable rules and regulations. So the tenure of renewal shall be on the term determined by the commission. So in Minister of Petroleum Resources and SPDC, OML 11, including 16 other OMLs, were granted to SPDC in 1960 for 30 years and renewed for another 30 years, in effect from 1st of July 1989 to expire on 30th of June 2019. In October 2017, SPDC applied for renewal of the license and paid the requisite application fee. In November 2018, DPR approved the renewal of the other 16 OMLs for 20 years, but did not approve OML 11. DPR further requested SPDC to open a negotiation with Minister of State for Petroleum Resources with a view of reaching their 40% interest in OML 11. Issue here is whether the minister is under any mandatory obligation to renew a license once a licensee certified statutory requirement, and the Federal High Court Abuja held so. The Federal High Court Abuja ruled pursuant to Section 113(1) of the first schedule of the Petroleum Act 2004 that it is mandatory for the minister to grant renewal law if all the conditions have been met. Rather than 30 years, this SPDC prayed for, the court ruled that OML 11 be renewed for only 20 years in line with Petroleum Act. However, in setting aside the decision of the trial court, the court for appeal position is that the word shall in the case can only mean a permissive action. DPR may, all things being equal, exercise the discretion and renew the mining license or lease. Analysis. The position of the law is that the renewal or otherwise of a license is at the discretion of the minister. Howbeit, it is my personal opinion that the draft main intent was to obligate the licensee to apply for the renewal of his license. In the same way, the government is mandated to renew the license provided the licensee meets the imposed condition. So I agree with the ruling of the Federal High Court. The areas for PML. So the areas of PML is related to OPL. It must be related to the OPL. So it is not a different area. It must be area related to the OPL. So such area must be outside the original license, must not be outside the original license where the lease is derived, or area language, or an extension. So the normal area normally today is 40% of applicable OML. So if you have OML, normally you're going to take at least 40% of it. Usually under the OML, it is 50 square miles, which is equal to 1,295 square kilometers. Relinquishment of PML, the condition is that after 10 years of commencement of PML, relinquish all parcels not within the boundary or deeper formations. 2, upon renewal or conversion, relinquish areas that are not areas that merit appraisal or declare significant discovery or declared of commercial discovery, or that is FDP is not underway, or that regular commercial production is not underway, is not going on. So the relinquishment dates will take effect from the renewal date or conversion date. So what the effect of relinquishment? One is that expiration of license, relinquished areas will go back to government, or paid this thing will not be refundable, and PML will designate back to what? To PPL. Revocation of PML. Conditions is that the licensee defaults in obligations, or the licensee does not initiate regular commercial production within the development period, or that the licensee ceases to produce in paying quantity. So what are the fate of the revoked PML? It expires, or it shall now, when it expires, it will go into a new bidding. So because if you revoke, it will take into a new bidding. So services, you must serve your notice. If you're renting, the revocation notice must be served in the address, the last known address of the licensee or its legal representative in Nigeria, or it must be published in a federal government gazette or website. So addition of revoked PML, if it's revoked, as I said, by default, the minister will within 30 days appoint an interim operator to coordinate the operation. Or if it's revoked because of not regular, because the acreage is not producing regular, the licensee will vest back to government administered by the commission. Not in Korea National Oil Corporation and others, versus OWL Petroleum Services Nigeria Limited and others. DPR conducted a bidding round in March 2005 for award of exploration rights to several oil blocks in Nigeria. At the end of the bidding round, ONGC Vidish Limited made the best bid for OPL 231 and 323 respectively. However, on 5th of September 2005, OPL 321 and OPL 323 were granted to NOC and their local content partners. Subsequently, on 8th of February 2009, NOC received a letter written by the Minister of State, HD Oden Ogumagobia San, on behalf of the late President Musa Yar'Adua, that the allocation of OPL 321 and OPL 323 had been void because they failed to pay the signature bonus for the license. By the same letter, the status of the ONG Vidish Limited as the winning bid was restored, subject to its payment of full signature bonus within the period stated by the letter. NOC was agreed with the voiding of the license and sought and were granted leave to apply for the judicial review. Issue is whether revocation of license by the President of Nigeria is subject to judicial review under the order of certiorari. The Supreme Court agreed with the Court of Appeal that the said letter conveyed the decision of the President of the Federal Republic of Nigeria to void OPL 231 and OPL 222 to represent executive order, which in circumstance is not subject to judicial review. This decision effectively quashed the ruling of the Federal High Court that the revocation was null and void. Analysis. This decision ensured that the court do not review the powers of the executive and legislative arm of the government, just as the judiciary would not want to review its actions by the other arms. The case of no would have succeeded if they had approached the court by way of originating someone. In passing, the Court of Appeal posited that the terms of the agreement between the parties and the facts and circumstances that gave rise to the application for judicial review demonstrate that the relationship between the parties were contractual. What falls for the determination under the issue is the procedure adopted by NOC for seeking redress, not the merit. So Korea Oil failed not because they don't have issue, they failed because they approached the court in the wrong way. So they would have succeeded if they approached the court in the right way. In Transitional Oil Nigeria Limited and Minister of Petroleum, Traditional Energy conducted the farm out agreement, farm out with the Chevron and NNPC JV on OML 49 with 2 fields and obtained minister's consent in the letter dated 20th of February 2017 from the DPR. Traditional Energy then paid the prescribed fee, but in January 2019, the letter from Chief of Staff of President Buhari Abakare wrote a memo invoking the earlier minister consent purported on the instruction of the president. DPR, without a notice to Traditional Energy, put the field in the 2020 marginal field basket, though the field were not part of the original 57 field approved for bid round. Traditional Energy then filed the suit against the action of the minister. The issue is whether the president has the power to revoke a PML duly renewed by the minister. The Federal Court held that the doctrine of presumption of regularity, all things being presumed to be rightly, for the action of the area had no locus to act in the manner he did. That the Honorable Justice counseled government officials to avoid to always abide by the contract entered into. 3, that the defendant did not challenge the claimant's deposition and exhibit of its financial statement and therefore awarded $20 million as liquidation charges against the government. Analysis. The government, in lieu of seeking to revoke license duly granted or renewed, should seek legal means to enforce specific performance of the provision of the contract. The law will always favor the idea that the breach of a provision of a contract is not sufficient ground to revoke the license. Assignment of license. Condition for assignment. A licensee shall not assign, transfer, novate of his rights, power, or interest thereof, or a shareholder in a JVC shall not sell, transfer, or its right without the consent of the minister, subject to the recommendation of the commission. So you cannot do anything with your license without getting the permission from consent of the minister as recommended by the commission. So, but the thing is that the minister cannot reasonably withhold his consent. He has to inform you 60 days after that why the license is rejected or not granted. So, and the commission must also act within 60 days. So there are time bound, and if they fail to act, that assignment is meant to hold and nothing can change it. So there are procedures to obtaining minister consent. The first thing is to indicate your interest to assign. So the assignor, which is the oil company, will say, okay, I want to assign my property. Once that is done, they will now get to the assignee, which is the person farming into the assets. The person farming to the company farming to the asset is assignee. He will notify the commission of the assignees. Look at the people who wants to sign into them, and he has some days to do that. Some rules follows that. After notifying the commission of the assignees, he will put up application to the commission, and the commission is meant to grant the application within 60 days. And if they fail to grant within 60 days, the application is meant to be granted. In Lake Oil 300 Limited and others versus Ministry of Petroleum, Lake Oil made an agreement to acquire Afren participating interest of PIA 310. Afren then applied for the minister consent in January 2016. The minister neither granted the consent nor explained his refusal of it. In 2017, the president issued Executive Order 1, mandating governmental agencies to publish procedures and timeline for obtaining relevant approval. The order further required government agencies to approve or explain refusal of an application within the timeline as published by it on its website, failing which the application should be deemed approved under the order. Based on this order, Lake Oil and Afren sued the minister, seeking a declaration that the minister's inaction on the application for the consent has given rise to a deemed consent under the executive order. The issue is whether the consent of the minister, being a fundamental requirement for the assignment or transfer of an interest in oil and gas asset, can be granted by default. That's the issue here. The court dismissed the suit and held that the consent of the minister is fundamental requirement for the validity of any assignment or transfer of interest on oil and gas assets. That the consent cannot be granted by default. That the consent must be positive, affirmative, and definite. That the position of the share capital and resulting participating interest of Afren Limited over OPL 300 valid. That the provision of executive order of May 2017 for ease of doing business are inappropriate to the instant application of the minister's consent. Analysis. The hardship caused by this decision is remedied by Section 95(7) of the Petroleum Industry Act, which ensures that the minister's consents can be granted by default on expiration of 60 days. Marginal field. Marginal field means a field or discovery that has been declared as marginal prior to 1st of January 2001, or which has been lying fallow without activity for 7 years after its discovery prior to effective date. That is Section 94(8)(a) of the PIA. If that no marginal field shall be declared under the PIA. So under the PIA from 16th of August 2001, no marginal field shall be declared again in Nigeria. Marginal field before the PIA. Before the PIA, marginal field had been suitably defined as Section 17 of First Schedule of the Petroleum Act in 1969 as it stipulates that the OML holder and the consent of and on terms of condition may be approved by the president. So before now, it's actually a matter of the president to define what a marginal field is, following certain criteria laid down by government itself. So the point again is that under the PIA, there are two kinds of marginal field, which is the producing marginal field and the non-producing marginal field. The producing marginal field shall continue to produce with the same royalty and farm out agreement and shall be converted within 18 months of effective date. Upon conversion, the petroleum profit tax shall be 15%. So if you have marginal field before, once you convert it now, the petroleum profit tax, the hydrocarbon tax should be 15%, not 30%. Non-marginal field, the marginal field shall be declared as a marginal field up to 1st of January 2001 and shall not be producing, and not producing shall be converted to PL. So if it's a non-marginal field, you convert it to PPL. So effect of non-transfer, because if the field may be transferred to government, if you don't transfer, you have to present FDP, you have to do farm out with the consent and in terms condition approved by the commission, or you relinquish the field. These are the effect of non-transfer of your marginal field. So conversion of license. The OPL, an OPL can be converted to PPL, and OML can be converted to marginal field. Conversion can be voluntary if you convert earlier of 8 months before effective, which is 23rd of February 2003, or that your license has expired before that time, you will be forced to convert. If you know that a license that expires before February 16, 2023 shall be voluntarily converted upon expiration. So if your license has expired before February 16, 2023, you will be converted compulsorily, and that is a voluntary conversion. Involuntary conversion is after that February 16, 2023, any conversion will be involuntary. So benefit of conversion is that you have tax incentive under the PIA, but whether the incentives are beneficiary to the company depends on the production price, capex, and opex. The PIA is designed such that the more production and higher the price, the more royalty and tax that accrues to government. So another benefit is termination of outstanding arbitration and court cases relating to PL or OML. But the question is, what if the judgment may be given in favor of the company in the outstanding case? So what do you want the company to do? The company just convert when he knows the matter is in his favor. So conversion and renewal regulations. So this regulation provides on the process at which you are going to convert. So the person to make the application at the company is holding the license. The content application should be the name, address, email, telephone numbers, companies making the application, the license, the type of contracts, the name of operator. So there are general supporting documents to this application. One is affidavit, a declaration, a notarized declaration to abide by all provisions of PIA. 2, 5 copies of the map of the lease. 3, adequate survey description of the boundaries. 4 is a sworn affidavit and notarized declaration that if you made it approval, you have to proceed with the work commitment. 5, a sworn affidavit that if a commercial discovery, if you have a commercial discovery, you have to retain the area and continue with and relinquish upon time. Five, that if he merits, if he declares significant recovery, that within 1 year of conversion, that such that within 1 year, the conversion date of renewal shall be relinquished. Now, the additional supporting document, one additional supporting document for OML designated as merit appraiser, commercial or significant discovery. In that case, you have to support a proposal stating the minimum of exploration period, related work commitment, an amount of parent guarantee, calculation of rent, first year rent, a sworn affidavit to provide the guarantee and pay, to provide guarantee and pay rent. So if it's where commercial or significant discovery, the document attached should be status, current status of work program, outstanding work program commitment, amount of outstanding work commitment guarantee, amount of outstanding parent commitment guarantee, the affidavit of rent paid, evidence of rent paid, it has one affidavit to provide for outstanding parent guarantees. Now, what if it is OML that is dated as FDP underway? That means you either on the way or it has regular production. There are a list of items that will be there. Again, if it is a production, a marginal field, a producing marginal field, there are documents you have to support it with. If it is a non-producing marginal field, you have a document to support it. A non-producing marginal field that is converted to PML, in that case, the FDP acceptable to the commission. You must provide FDP acceptable to the commission. Period for conversion must be 4 months. If it is voluntary, you do it 4 months before the 16th of August 2023, February 2023. Sorry. If it's involuntary, it must be 12 months. Approval for conversion. For voluntary conversion or relinquishment and non-producing marginal field is 30 days. For involuntary conversion, producing marginal field and non-producing marginal field for conversion into PML, it is 90 days. When the minister refuses to grant the license, the commission shall inform the applicant of the reason for the refusal and permit the applicant to represent its application within 30 days of being informed of the rejection. Withdrawal of application. An applicant before approval can withdraw his application. Sign of contract. Once it has been approved, the parties can come together and sign the contract, the conversion contract, on the following ground: that he has paid applicable fee, provided that provided the applicable work commitment guarantee, provided the applicable parent commitment company guarantee, establish the decommission and the abandonment fund, provide evidence of contribution to the environmental remedial fund, provide evidence for contribution to the host community development trust, and provide statement with a statement with the sign of LNPC, because before this contract will happen, the conversion will happen, LNPC must sign up to it. Unitization, where a petroleum is covered by the license, the commission upon notification may require the applicable license to enter into a unit agreement and carry out all petroleum operation to the lease as a unit for the period of at least 2 years. So that's unit agreement. If reservoirs extend beyond their boundary, so the people who are adjacent will be forced to work together as a unit. Utilization for lease not covered by license. So if that lease is not covered by license, what happens? When the reservoir extends beyond the boundary of its lease into adjacent that is not covered by license, the commission upon notification may extend the boundary. So if my lease extends beyond my normal given lease, I have to notify the commission. The commission may now extend my boundary beyond that point to cover those areas. The unit agreement is essential. So for you to have a unit, you must have a unit agreement. That's the important thing. So what's the sense of unit agreement? Unit agreement resolve the legal issue of trespass, because the field you have has trespassed into another field. So it's a trespass by law is illegal. So trespass is not a legal term, is an intrusion into another land in violation of another's rights to exclusive possession. Surface trespass is clear. If you cross the line, you cross the line. If you place a well or facility on a reservoir of another, or on a reservoir of another, it amounts to trespass. However, subsurface trespass is trickier because there is a given that petroleum fluid will migrate virtually off track or unit. So gas flaring. Gas flaring could be AG or NAC. AG, where crude oil is produced, some AG is produced with it. The prime objective is to produce oil, in which case AG is regarded as a byproduct. As a result, crude oil is what controls and drives the production of AG. This is in contrast with NAG, in which case the prime objective is to produce free state natural gas, and as such, the production of gas is itself controlled. Being that the production of natural gas can be controlled, there is no economic sense in producing NAG without market and then flare it. The same cannot be said as NAG, which is a byproduct of oil production. AG flaring has a direct ongoing environmental cost, and addressing it is a co-commitment to the UN Framework Convention on Climate Change. The flaring of AG is one of the most egregious environmental and energy waste process in Nigerian petroleum industry. While AG flaring level has been declining in years, it still is a prevailing practice in the petroleum industry. AG flaring affects environment and human. All right. So what are the basis of natural gas flaring? It is Associated Gas Regulation Act 1979, Section 3.2. What's the fate? Associated gas has three fates. One is that it can be own use. Two, it can be sold. And three, it can be flared. So if you flare gas, you have to pay penalty. So if you flare gas, you have to pay penalty. So application for a licensee who flares gas except under exceptions commits an offense and is liable to a fine prescribed by the commission. Section 105.1 directs the licensee that the licensee shall pay penalty prescribed in Section 13 of the Gas Flare Regulation Penalty 2018 as follows. Where 10,000 barrels of oil or more is produced, gas flare penalty is $2 per 1,000 scoff. Where less than 10,000 barrels of oil per day is produced, gas flare is $0.5 per 1,000 scoff. Application penalty. So this fine shall be paid in the same manner as royalty. The fine shall be eligible for, it shall not be tax deduction, but in other regime before PIA, it is tax deductible. The fine shall be applied solely for environmental remediation and for relief of host community. What's my take? Section 103 has created a fund for environmental remediation and Section 240 for host community. So applying gas flare for these funds is redundant. My view is that gas flare penalty should be applied to develop an effective gas gathering, processing, transportation, and storage facility. There are many stranded gas offshore production platforms. It could be of immense economic benefit to make this gas available for domestic consumption at a very cheap price. More so, industries and homes could be incentivized to use more of gas-fired generators. More of our gas turbines are not operational because of lack of gas. This could be reversed. So, for instance, in ExxonMobil Producing Nigeria Limited FRS, Exxon had implemented a program to utilize and re-inject AG, where it was possible and appropriate. Mobil would flare the gas and would pay the prescribed sum to government. Mobil paid 3.126 million to 3.129 million and 2.276 million in 2016 and 17 and 8 year of assessment, which were receipted, but the minister failed to issue it with certificate. In October 2002, FRS sent Mobil with 3 notices of additional assessment of $7.633850 million, being the additional petroleum profit tax liable for the 3 years of assessment and disallowed a deductible expenses, the gas flare penalty payment. Mobil objected to the notices on the ground that the payment constituted deductible expenses under the law. FRS refused and considered the objection invalid. Mobil then appealed to the Tax Appeal Tribunal, Lagos Zone. The issue is whether gas flare payment can be treated as a deductible payment expenses for purpose of computing tax liability. On 17th of March 2015, the Tax Appeal Tribunal found for Mobil. FRS was aggrieved by this. decision, and on 16th of April 2015, lodged an appeal at the Federal High Court. The court allowed appeal on 26th of March 2018. The matter then proceeded to the Court of Appeal. On the 18th of March 2021, the court ruled in favor of FRS on the ground that gas flare payment is a penalty, and as such it cannot be categorized as expenses wholly exclusive and necessary, and by the canon of jus generis cannot fall within the parameters of allowable tax deductions under section 10(1)(l) of Petroleum Profit Tax Act. Analysis. The Court of Appeal was not properly guided to the fact that gas flare payment was not a penalty. That the receipt indicated by the minister bore payment for penalty on gas flared does not make it so. 1. Section 3(2)(b) of Association Gas Regulation Act of 1979, being the basis for gas flare payment, never said it was a penalty, nor Section 13 of the same act, which specified the gas flare payment amount. 2. Penalty arose when a licensee flares gas without certificate from the minister, and this was not the issue before the court. The Court of Appeal conflated Section 4 and Section 3(2)(b). The gas flare payment cannot require a certificate at the same time be a penalty. Note that the PIA labeled gas flare payment as a penalty. So under the new law, it is a penalty, it is not deductible. But what Mobile is pursuing currently, because must hold on the old regime. This case is in 2001. Last, it will be interpreted not on PIA, but on Petroleum Profit Tax Act. So in my opinion, Mobile has a good case at the Supreme Court. So, environmental management. Licensee to within 1 year of effective date or 6 months after license grant submit for approval environmental management plan. So you must submit for approval environmental management plan. So the framework for the plan has been Section 102 of the PIA, Section 20 of the Constitution, Section 102 of the PIA. The one thing awkwardly, the PIA made no particular reference to any existing environmental regulation or guideline, such as the National Oil Spill Detection and Response Agency Act, NOSDRA, and the Environmental Guideline and Standard for Petroleum Industry in Nigeria. That being said, the Environmental Guideline and Standard for Petroleum Industry in Nigeria is the guideline for understanding environmental plans. So that guideline will be followed strictly. Now, in Center of Oil Pollution Watch NGO and NNPC, the NGO claimed against NNPC the restoration of INE and Aku streams, the only sources for water supply to the Acha Anonymous community in Isukwato local government area of Abia State, contaminated by oil spillage occasioned by the negligence of NNPC. The NGO further claimed the provision of medical facilities and treatment of victims of the oil spillage by NNPC. NNPC entreated the trial court to strike out the suit on the ground that NGO lacked necessary locus to initiate and maintain the action on the alleged oil spillage. Preceded by the argument of the NNPC, the trial court struck out the suit for want of locus standing on the part of the NGO. The NGO's appeal to Court of Appeal, Lagos Division, having been dismissed on the ground that it lacked merit, appealed to the Supreme Court. The legal issue is whether NGO have local standing to commence and maintain action on environmental matters. The Supreme Court unanimously allowed the appeal. The matter was remitted to the Chief Justice of the Federal High Court for reassignment to another judge for expeditious hearing and determination analysis. Decision is final, but I especially agree with the Dayo Akpata, Solicitor General of the Federation, and Awole Olunkunu San, two of whom they are amici curiae, that in the absence of harm, injury, benefit or obligation to the persons bringing the action. Such a person will be likened to a busybody who lacks the local standing to initiate the action. In this case, there was no nexus between the relief being sought and the NGO. I am not saying that there is no merit in the claim of the NGO, but it lacked the standing to institute and maintain the action. By Section 20 of the Constitution, the responsibility to commence and maintain action against environmental pollution rests on the AGF, Attorney General Federation, or government agencies such as the Commission, the Authority, NOSRA. Alternatively, a member of the political community could bring an representative action for and on behalf of the community. Decommissioning. Decommissioning and abandonment means approved process of cessation of operation of crude oil and natural gas wells, installations, plants and structures, including shutting down and installations, operations and production, total or partial removal of installations and structures where applicable, chemicals and other material handling, removal and pollution of debris and removal of items, environmental restoration of the area after removal of installations, plants and structures, Section 318 of the Act. The standard must be international standards. It must follow the guideline of the Commission, and the written approval must be granted. My take, the way manner Section 231 and 5 were couched will throw up the same issue as Minister of Petroleum and SPDC, in which case the obligation to apply for renewal is discretionary and the corresponding obligation to assent is mandatory, just as I said in that case. My personal opinion is that the draft main intent was to obligate the licensees to apply for the decommissioning and abandonment. This ensures that the licensee do not abandon without proper decommissioning. In the same way, the government is mandated to approve the decommissioning and abandonment plan, provided the licensee meets the approved conditions. So I don't know if I still have some time to go over jurisdiction, or should I stop here? Hello?
Thank you. Yes, thank you so much, Dr. Oko.
Okay. Should I stop or should I go on with the next procedure? The next?
The timing restriction, yes.
Okay, thank you.
Thank you so much, Dr. Oko, for such an insightful session. Okay, so we'll be going on to, we'll just be doing a summary now of the presentation, sorry. Well, before then, I'll just call on the section chair.
Thank you, Dr. Oko, for a great session. Sorry to take a minute of your time. I just wanted to acknowledge a few people who have served on the SPE board, and I identified them from this call. We had a section director who was section chairing for the 2016-2017 board. She was on this call, and I see Bola Femi Sali on the call. I also see Chinedu Okbala and Femi Salako. Just wanted to highlight them from us because they've served on the board and they're part of the built structures that we stand on today. So this is us saying thank you for joining us. All right. So Irene, over back to you.
Thank you, section chair. So we'll just be doing a quick summary of this presentation. Thank you once again, Dr. Oko, for such an insightful presentation. So the PIA framework is in 5 modules: the governance, administration, hosts, communities development, fiscal framework, and legal. And we had a focus on the legal today. Just a quick summary of what was actually gone through. The minister has the responsibility for overseeing the petroleum industry on behalf of the president. The bidding process must be fair and transparent and also competitive. Licenses must be accompanied by a contract. Then also we spoke about the types of conversions, OPLs being converted to PPL and OMLs being converted to PML. We also spoke about the voluntary conversion or relinquishment, which is at least 4 months. Then involuntary conversion is at least 12 months prior to expiration of license. Production of natural gas can be controlled. Flaring, as we all know, affects the environment. There's a penalty which is attached to gas flaring and will be paid in the same manner as royalty. So that was just a conclusion of our summary, just as we go into the question and answer section now. So once again, if people can just, our attendees, if you can just drop in your questions on the comments, in the comment section. So one question is, can we get the recording for this session? I believe that will be made available after, as this is a recorded session. So a question to you, Dr. Oku. Will you say that enough is being done for the communication of this new act in the industry?
It depends. The answer is not a straightforward thing. Some companies have done well to communicate this to their people, while some companies have showed little or no interest about the act. They are still working as if they had the old act working together, as if the new act has not taken effect. The new act has taken effect. So it depends. Some companies have done a lot, some have not, because I was opportune the other day when I was doing some economic model, you see, for a company. And I saw a well-documented Excel sheet economic model based on PIA from NMPC. So that means that they have taken their best resources to hand the economic model. I was impressed when I saw the model, because all the nitty-gritties and questions I was asking, because as a lawyer and engineer, I'm able to fix the legal aspect to the operation. The physical regimes are married with the petroleum industry. So, and it's a difficult thing for single person to really handle. When I saw that Excel sheet, I was impressed. All the questions that are hidden were answered perfectly well. They used the right rates, the right understanding, the right process. So why am I saying this is that there are some companies that have taken extra mile to do due diligence on this PIA, while some have actually not done anything. They don't care, they don't bother about it, they're just hoping. And the fact is that the government do not care. NMPC has this, they've already done their job. Tomorrow they will post, that is why my point of saying this. They don't care if you follow the law or not, they don't care. Tomorrow they will check you. And when they check you, don't follow the law, you pay the penalty. At that time, you start spending money going to court. The barrage of cases I listed here are just simple mistakes. People do not follow a simple law or something, or government decided to act ultra-violent, act beyond their power. These are the cases that come up. So companies had every chance to do their job, but some have not done. Some have done perfectly well, understood the law, used the law, and it will benefit them at the long run.
Thank you for that answer, Dr. Austin. Very well said. Desmond Agboifo, your hand is being raised.
Absolutely. Thank you very much. Thank you very much, Dr. Austin, my colleague, my senior colleague. And thank you so much for this session. It's my first time in this session. And I just want to throw a bit of some points. So the last question and also buttress engineer Austin's answers. The answers are not perfect. Companies in the region are trying to come to the reality of what the PIA is. And that's the truth. And of course, looking at the forerunner, who is the NMPC or the NMPC Limited, trying to drive that process and trying to even create models, as Austin has said, is also very, very commendable. But however, what I've seen in practice, anyway, I consult for the industry on the side too, and smaller firms are trying to assess the value in terms of migrating from a PML to its derivatives, and also trying to see how they can even pick up new assets. I mean, he has done a good job in this presentation, but the key thing is the discussion should be on. The quest to make sure that companies really understand what the PI is an ongoing process, as I've seen in the last few months. So yes, I think there's progress, but there needs to be a lot more awareness and impact, I'm sure, from PI's point of view and under the SPE. Thank you.
Thank you very much, Desmond Agwefo. So, like, just backing off from what has been said, ignorance is not an excuse. Each individual as well as organizations are encouraged to actually go away and just look into this PIA. How does it benefit you, your organization? Then also the distinctiveness as well, with the upstream, midstream being described as well in this act, as well as downstream, and the new regulators as well. So another question we have, what are the current oil in water ppm requirements allowed for discharge in inland water and swamp operations as provided in the PIA?
Okay, the PIA referred, as I said before, the environmental aspect, the PIA did not make specific reference to any act, but the Environmental Regulation Act of 2018 is the basis. And in that regulation, it provided the exact parts per million of what oil in water that could be disposed. So if you can contact me later, I will share with you the exact number. But I don't have it because the number are plenty on different conditions. So I cannot say the number offhand. But I can always give you a number if you can contact me later, the exact number that will be required, and it's based on the Environmental Regulation Act 2018. So I will give you the exact number if you can contact me later on. But I don't have it offhand to mention the number, but I know there is. Thank you.
Thank you, Doctor. We have another question. Do you think the Minister of Petroleum has been given too much power by the PIA? Are there conflicts in a case the President doubles as the Minister of Petroleum?
The minister the power is not really changed. Though what happened was that the law made it mandatory that, okay, if you say you are not going to grant a license or not going to take an action, what happened, the power was curtailed by giving the minister a time to respond to any request, to any act. But if he fails to act, some are 60 days, some are 90 days, like to grant license, if he fails to grant within 60 days, that license is deemed granted. So the power of the minister actually did, because that's what people say that PIA is a old wine in a new bottle. That's those men to look at the governance. If you look at the PIA governance strictly, PIA is actually an old wine in a new bottle. The only thing that changed drastically with PIA is the fiscal regime, the tax, the fiscal aspect of it, the economics, that really changed drastically. Now, if you view from the sense of governance, the powers of the minister actually did not change. Rather, what happened was to curtail, due to the case of Lekoye, when they filed a suit against, because Vice President sometime in 2018 or so organized and gave an order that if you fail to perform your duty as a government official after some time, that duty is deemed performed. So with that order, Lekoye and our friend were able to challenge government that, look, we've applied for a license for years and that license has not been approved. So by this order, that license is deemed approved. So the PIA bought into that order. It will be PIA is working on that order to make sure that the minister does not have this kind of federal asset right to check anybody. So that singular act in the PIA curtailed the power of the minister. Outside that, the minister still has all his power intact. Nothing changed. And now, whether there's a conflict of interest by the president? No. The president appoints ministers by section, I forgot the exact section in the Constitution. He has the right to appoint his ministers. So the minister is working on behalf of the president. He's not the president, he works on behalf of the president. So the president can say, okay, I don't want to appoint you as a minister, so I want to be the minister. So there's no conflict of interest there. The Constitution allows it in the first instance. Thank you.
Thank you, Doctor. We have another question. Where can we get data on the list of licenses running or expired? Because the last oil and gas report shared by the DPR was that of 2018. They have stopped publishing since 2019, and I strongly believe that this should be open to the public.
This question is interesting. The PIA mandates the commission and authority to disclose and publish information on oil and gas licenses on their data, on their website. It's mandatory. But the question is this, you see, the problem I have with government is that a law will direct the government agencies to do an act. They will not do that act. And there's no way you can challenge that non-performance of government act unless the government will police itself. So my view is that if there's a way, just like the law says, if the minister does not do his job, is doom granted. There should have been a way to create things like, if you fail to publish these things, there's a penalty to that source. But I'm thinking how to manage that kind of scenario, because now, publishing an article on a website, disclosing information now, is something personal, because the commission is the owner of that information, actually. So the law has mandated to disclose it. But don't disclose it. As he said, this person is current. The current publication in the commission's website is up to 2018. There's no 2019, no 2020, no 2021. And that is wrong. By law, they should be able to update the people, the Nigerians, every point in time. But you watch out, they'll publish 2019, maybe in 2024. It doesn't make sense. And by then, you cannot, throughout my research, I was trying to see if I can get the recent flare gas. I could not get recent flare gas. My flare gas only ended in 2018. So, no, because we cannot, this information is not available. There's nothing you can do to check government. Government sometimes behave in a way that I don't understand, even when the law has asked them to do so. So thank you.
Thank you, Doctor. So we have now come to the vote of thanks. I would like to thank you all for coming out. Okay, we seem to have one more question, sorry. And I think we should take it. What is the PIA's position on our refining assets downstream, and all the refineries are not producing to nameplate capacity?
The PIA provided for the downstream and midstream administrative structure. That was not part of our classes, our presentation today. Our presentation today is basically upstream, but it did sufficiently provide for refinery. It did, but that is a different story altogether. But be rest assured that the PIA did provide for it and provide adequately. However, the question will be whether the provision made by the PIA is sufficient to grow the refinery, to grow our industry. I don't believe so. If I were part of the draft people, there are certain things I would have tried to include to ensure that the PIA encourage local refining and other things again. But the way it is drafted, the downstream midstream, because refining is a midstream process. It's a midstream.
Okay, Doctor. Thank you for your responses so far. Thank you all for such an interactive session. Thank you to our speaker. Thank you all for taking out time to come in today. I'll just like to do the announcement.
Downstream is also gas processing process. So downstream are basically retails, but there are provisions for it entirely.
Okay, thank you, Doctor. So just to move on to the announcement, please anticipate the virtual symposium on packing crude oil theft in Nigeria. Effect on Economy and Sustainable Solutions. The date for that is 29th of November from 10 a.m. to 4 p.m. We also have upcoming the end of year children's party and back to school gift boxes. That is on September 10th, 2022. Okay, also the SPE, join, renew your memberships. You can contact the SPE admin. I'll be putting in the details on the next slide. And then we also have, sorry. So I hope you can all see it properly. So for further information on membership, you can contact the member chair, LSC Ezewane, Adewale Egunleye, and Odion Okosun, who is our section admin. Their numbers are being shown on the screen today now, and it will be shared as well. So connect with SPE Lagos as well on all our social media platforms. We're very interactive. We have on LinkedIn, SPE Lagos section 61, on Twitter, SPE_Lagos, Instagram, SPE_Lagos, Facebook, SPE.Lagos, and on YouTube, SPE Lagos. We have a lot of content. So for inquiries on SPE registration or membership renewal, like I mentioned before previously, their details are showing on the screen now. And for SPE membership benefits, please visit www.spe.org/en/members/benefits. So I'd like to encourage all of us to please turn on our videos for a photo session. So we'll be bringing in, I'd like to call in our SPE admin, Odion. Odion, I can't hear you. I don't know if it's my audio.
Ari, can you hear me now?
Yes, I can.
Okay, so waiting for others to turn on their videos. We want more people to turn on their videos, please. Kindly turn on your videos. Let's see your smiley faces and get clicking. Okay. All right. Okay, hold on. Let me make you, okay, right. Yeah. So I just activated you to be able to turn your videos. So please carry on. Aha, thank you. Thank you very much. Thank you very much. Okay, I'll do a countdown to 5, 4, 3, 2, 1, and we'll start clicking. All right. Put on your best smile. Time for makeup is over. Let's get clicking. Okay. All right. Thank you. Thank you. Thank you. Thank you. Thank you. Let me go to the next page and see. Okay, I'll take here. Thank you. Thank you. Go to the next page. Okay, so let's just do it one more time with our hands like this. When I say SPE, you just say oil and gas with a lovely smile. Thank you. SPE.
Oil and gas.
SPE. Okay. Okay. Thank you, everyone. God bless you. Back to you, Irene.
Thank you so much. Thank you, everyone, for taking out time to come out today. And we have reached the end of this technical session, and we look forward to receiving you to others. Very informative and very engaging and interesting. Thank you all.
Thank you. This meeting will end in 5, 4, 3, 2, 1, 0. Thank you. Enjoy your